welcome to the premiere of Dead On. This is a brand new TV show. And tonight, lucky enough to have John Dawson, who's done dozens of Chapter 11 bankruptcies, with us as a guest. And we're going to be talking about an interesting new twist to Chapter 11 bankruptcies called Subchapter 5. So John, why don't you give us a little briefing on subchapter 5 and chapter 11 and what the changes look like and what would a client be required to relate to us so that we can have an idea how they stood. Now, one thing before you go, John, I want to say this is an attorney advertisement and the content is not legal advice. So go ahead, John. Tell us a little bit about subchapter 5.
Okay, so just so that people who aren't familiar with bankruptcy and the differences of the various chapters are aware, Chapter 11 is a reorganization, typically, for a company or a business entity, or even with the new law, it appears individuals operating a business as a fictitious business name might be able to get the same protections under this code section. Whereas Chapter 7 is when somebody is adjudicated bankrupt in the sense that people traditionally think of it. I have no more money, I got to sell my things, and I'm left with whatever there is. That's not the case about bankruptcy, and people need to understand that bankruptcy is a very valuable tool, and very smart people created it to give people a chance to essentially wipe the slate clean and start over. So Chapter 11 is what we call a reorganization, and a subchapter 5 is a brand new statute, not even a year old, that applies to small business entities primarily, as opposed to any business entity or very large business entities. And that's measured typically by the amount of debt. And after COVID, the subchapter 5 started in February, and the CARES Act came in March 27th of 2020. And it said any business, the original subchapter 5 said any business under $2.5 million, $2.25 million in total aggregate debt qualified. But under the CARES Act, a month later, after COVID began, the Congress moved it up to $7.5 million. That limitation is around until March 27th of this year. I suspect it might get extended, but people in a position of having that level of debt or any level of debt operating their small business should understand that the bankruptcy provisions can help them tremendously. And they can also stay in business. This might be a subject later on, but they can continue to operate their business as what we call a debtor in possession after you apply to the bankruptcy court for protection.
Okay, John. So let's say I was a client and I'm interested in, exploring my options on a Chapter 11 or a subchapter 5. And what kind of documentation, what kind of facts and figures would a bankruptcy attorney want to see to give you an idea of how you stood in this whole situation?
Well, relative to any business's reorganization specifically, or any bankruptcy, frankly, you need to know everything there is about their assets and their debts. And what, in terms of assets, that's a whole list of things that includes how much cash you have, what type of operating revenue you are still getting, especially in the era of COVID, what type of lease you hold with generally a commercial lease, how much time is left on the lease, is it above market, is it below fair market value? All of these things are assets and things to consider. I mean, there's actually quite a list more. And then we need to look at every single creditor that you owe or that your business owes, depending on if you distinguish between yourself as an individual and yourself doing business. And generally, without an entity, that's a little harder, but the rule applies apparently just the same under subchapter 5. So in terms of details about debt, I think it's pretty self-explanatory, but it's amazing how many people, feel like it's quite a bit of work in the beginning, but it's just critical that for the bankruptcy filing that when you first file the petition, that you have every single creditor named, because if they're missed, then any discharge, which means wiping out of the debt or reducing the debt, doesn't count if that
Okay,
creditor
so
didn't
you'd want to
receive your release.
see their arrearages, you'd want to see their taxes owed, if they
Oh,
have a lien on
absolutely. Yeah. What's owed
personnel,
under the lease?
if they're behind on their rent,
Right.
if they have vendors that
All the
deliver
trade,
products.
all the trade accounts, trade debt, vendors. Yes. Let's see. Yeah. I mean, absolutely everything. What you pay your janitors, what you pay your personnel, everything that's owed, taxes, payroll taxes, hopefully, people can get behind on all of it. And it's just critical that every aspect of that is made known. But, typically that's fairly easy information to acquire.
Okay, well,
And we
what
can
we're
go
gonna
over it in
do,
greater detail when someone comes to see us.
yeah, like I said, we can do another show in greater detail, or they can call or shoot us an email and we can give more information on that. Now we've got to kind of wrap up our first premiere show of Dead On,
Oh,
and
gotta go
we're
over
going to
time.
move on. And we appreciate everyone coming and watching us. And, we really looking forward to doing some more shows and trying to make some of these more complex laws a little more understandable, at least from the client standpoint, and how it affects them. Okay,
Now,
so
they
John,
primarily need to understand that this is a tool. This is not a representation of some personal failure. Use the bankruptcy tools as they were meant to be used to help you start fresh, but maintain your going business. Work with all the creditors and move forward as a business. And over 3 to 5 years, you pay things down little by little, sometimes in very small fractions. It depends on the nature of the debt.
okay, John, thanks for coming on, and we'll see you on the next Dead On. Right.
Thank you very much, Mark. See you then.